Welcome back to the Constitutional Clarion. A number of viewers have asked me to explain and consider the constitutional validity of racial hatred laws that have been recently passed at the federal level and proposed in New South Wales. In this video, I'm going to look at the New South Wales proposal. The main reason for starting with New South Wales is that there is a really useful report on the subject by the New South Wales Law Reform Commission that was chaired by the former Chief Justice of New South Wales, Tom Bathurst. This report was handed down in September 2024, so it's very recent, and it provides all the necessary context and discussion of these proposals, as well as quite useful analysis. The other reason is that it seems that the New South Wales Minns government, perhaps for the reasons that I will outline in this video, has had second thoughts and has dropped the main plank of its reforms. So what did the New South Wales government initially propose? On the 6th of February, the Premier, Chris Minns, and the Attorney General announced a package of reforms to deal with racial hatred. The key reform was to introduce a new criminal offence for intentionally inciting racial hatred with a proposed maximum penalty of 2 years imprisonment. In addition, there were some other provisions concerning places of worship and some minor changes and tweaks which increased penalties for existing offences or clarified their application. The day that I'm recording this is the same day that two bills were introduced into the New South Wales Parliament, so that we can now see the full detail of what is proposed. First, there's the Crimes Amendment Places of Worship Bill 2025. It makes it an offence to block access to places of worship or to harass, intimidate or threaten a person who is accessing or leaving that place of worship. The maximum penalty is 200 penalty units or 2 years in prison, or both. Excluded from the scope of this provision are acts that form part of industrial action or which occur outside Parliament House, which happens to be across the road from a church, or which occur outside a member's office, or which occur with the consent of the Commissioner of Police, or with the consent of the person who's in charge of the place of worship. Also excluded is participation in an authorised public assembly under the Summary Offences Act. This new provision is quite similar to another anti-protest provision concerning blocking access to major facilities such as railway stations, public transport facilities, ports and energy facilities. Now, part of that provision was held to be invalid by the Supreme Court of New South Wales in the case of Caveld and the State of New South Wales. It's known as the Knitting Nanas case because it was the Knitting Nanas who actually brought the case. And it was held invalid due to its disproportionate restriction on the implied freedom of political communication. While the parts of the provision that protected the facilities from damage and serious disruption were held to be valid, those parts that criminalised behaviour because it merely caused inconvenience by blocking access to train stations, for example, were struck down as invalid. And this was because the adverse effect on freedom of political communication significantly outweighed the benefit that was sought to be achieved. So the New South Wales Parliament, in this case, will have to be very cautious about how it strikes that balance to protect free speech in relation to this new provision. The bill also authorises police to issue move-on directions to those who are engaged in unauthorised acts blocking access to places of worship and harassing the people going in and out. Such powers, however, already exist in Section 197 of the Law Enforcement Powers and Responsibilities Act 2002, where police can issue move-on orders to people who are obstructing persons or traffic in a public place or harassing or intimidating others. Failure to comply with such a direction is an offence. Now, all this new provision in the bill does is to prevent acts outside places of worship from falling in an existing exemption which applies to genuine demonstrations, protests, processions or assemblies. The second bill is the Crimes Legislation Amendment, Racial and Religious Hatred Bill 2025. This is where one would expect to find the new criminal offence for intentionally inciting racial hatred, with the proposed maximum penalty of 2 years imprisonment. But if you look for it, and I did, it's not there. Instead, we get some minor tweaks to existing laws, nothing of great significance. First, it ensures that to the extent that existing laws about inciting violence are directed at public acts, that term public acts is defined to include graffiti. So it's really just a clarification of something which seems fairly obvious. Second, it repackages an existing offence about displaying Nazi symbols to increase the maximum penalty from 100 to 200 penalty units or imprisonment from 1 year to 2 years if it's done on or near a synagogue, a Jewish school or the Sydney Jewish Museum. Existing exemptions do continue to apply, including for the use of a swastika in connection with Buddhism, Hinduism and Jainism, and when done reasonably and in good faith for an academic, artistic or educational purpose, or for another purpose in the public interest. Now, I've already done a video previously that discusses the constitutional validity of anti-Nazi symbol laws, so on that point, go and have a look at that video. Third, the bill tweaks an existing law that makes it an aggravating circumstance when sentencing an offender that the offence was motivated by hatred or prejudice. All the amendment would do is clarify that this applies when the crime is partially or wholly motivated by hatred or prejudice, as opposed to just motivated by hatred or prejudice. So again, not a lot. Fourth, it amends the Graffiti Control Act 2008 to make it an aggravating circumstance if graffiti is marked on a place of worship, leading to higher penalties. Again, the offence already exists, so this is just really a repackaging effort with slightly higher penalties. In practice, will any of this actually stop people from committing offences involving racially offensive graffiti? I find it quite hard to believe that someone who is filled with the hatred that motivates such action is going to be particularly perturbed that now it's an aggravating circumstance if they're only partially motivated by hatred. Nor are they likely to be worried that putting graffiti on a place of worship is an aggravating circumstance, because it's already an aggravating circumstance if you mark a building with graffiti that's not readily removable by the use of water or detergent. Might they stop their behaviour because there's a higher penalty for displaying Nazi symbols near a synagogue or a Jewish school? I suppose it's possible that a rational person might take that into account, but I suspect that most people, when committing these acts, are not making rational calculations about penalties. In fact, most of them won't have a clue about these changes anyway. So what are these laws really about? Well, being seen to have done something seems to be the obvious conclusion. Now, that's not in itself just a political exercise of self-justification. It does have a point of setting a standard and reinforcing to the community what is not acceptable. It's also a signal of support to those groups in the community that feel threatened. But beyond symbolism, these reforms seem unlikely to have much of a practical effect. Now, what about the elephant in the room? The missing criminal provision about inciting racial hatred. At the time I'm recording this video, there's been no explanation of what happened to it. But by the time you see this video, there probably will be. So my guess, for what it's worth, and hopefully you know by now, but my guess is that it was dropped due to disagreement about how far the provision should extend to different groups that are affected. But underlying all of that, there are also genuine concerns that were raised by the New South Wales Law Reform Commission in its report, where it declined to recommend such a law, and they're worth looking at. At the moment, in section 93Z of the New South Wales Crimes Act 1900, an act which threatens or incites violence towards another person or group on the grounds of race, religious belief, sexual orientation, and a number of other listed attributes is a criminal offence. Now, this is because violence, inciting violence, and threats of violence all tend to fall into what is traditionally seen as the criminal law. While this offence is rarely prosecuted, this is most likely because the same conduct gives rise to offences that it's much easier to prove without having to go through and show and prove all the racial elements. For example, a person could be convicted of offensive language or common assault or stalking or intimidating another person or destroying or damaging property or threatening to kill or threatening to injure a person or threatening to damage property. All of these things are criminal offences already. If a person is convicted of those offences, a motivation of racial hatred can then be used in sentencing as an aggravating factor that leads to an increase in the penalty. Other acts, such as those that incite hatred towards, serious contempt for, or severe ridicule of a person on the grounds of race, religious belief, or other specified attributes, are unlawful under the Anti-Discrimination Act, but are not criminal offences. Complaints are brought by individuals, and if they're accepted and cannot be resolved by conciliation, they can be referred to a tribunal, NCAT in New South Wales, which has the power to order the payment of damages and issue orders restraining future conduct or requiring a public apology. What the Minns government proposed was to turn this unlawful act, which was non-criminal, into a criminal offence. Why is this problematic? Well, the New South Wales Law Reform Commission pointed out that because criminal penalties, including imprisonment, are very serious, it is important for the law to be precise and clearly understood across the community. Terms such as hatred mean different things to different people. This ambiguity makes it an inappropriate standard for the criminal law. There are already difficulties with applying the term hatred in NCAT because it involves an impressionistic rather than an empirical assessment. Given how hard it is for lawyers and judges to assess, how do members of the community know when they've crossed the line and committed an offence? At what point does criticism of the conduct of a foreign government amount to inciting hatred against the people of that country? Would Invasion Day rallies be treated as inciting hatred against people of British origins? Would religious teachings against particular practices be treated as inciting hatred against groups who engage in those practices? The borderlines here are unclear, making criminalisation of such matters problematic. The New South Wales Law Reform Commission warned of potential unintended consequences, including a potentially disproportionate impact upon disadvantaged groups, including Aboriginal and Torres Strait Islander peoples, people with a disability, and young people. It also expressed concern about potential overreach and the criminalisation of legitimate free speech impacting upon democracy in New South Wales. The Commission noted that there are limits to the role of the criminal law in trying to achieve and maintain social cohesion. Such a law could end up alienating and marginalising groups in a way that actually deepens divisions in the community. Passing laws quickly in the context of a particular crisis and without proper scrutiny is, of course, unwise. It can lead to unintended consequences. It was sensible of the New South Wales Government to refer this matter to the New South Wales Law Reform Commission for proper, sober consideration. But it would also be sensible to listen to what the New South Wales Law Reform Commission actually said. Perhaps they did. Thank you for watching the Constitutional Clarion, and as always, I look forward to seeing you again next time. Goodbye.